Welcome back to the deep dive. It is February 16th, 2026.
We're settling into the new year.
We are, but the Supreme Court has already dropped a huge decision. I mean, this thing is going to ripple through the entire criminal justice system.
It really is.
Yeah.
It came down just last month, January 14th. The case is Barrett v. United States.
And this is one of those cases that, on the surface, it looks really technical. You know, all statutes and sentencing rules.
But when you really peel back the layers, it asks a really fundamental question about the power of the government.
Yeah. Okay, before we get into all the heavy legal stuff, I want to start with a riddle for you.
Okay.
Or maybe it's more of a nightmare scenario. Imagine you do one thing. One single bad act. Can the government charge you for it?
Obviously, yes.
Of course. But can they convict you twice for that one act? And I don't just mean like a backup charge. I mean, can they punish you, send you to prison for crime A, and then add more prison time for crime B when A and B are basically the same thing?
Most people's gut reaction is, no way, that's double jeopardy. The Constitution says you can't be put in jeopardy twice for the same offense.
That's what I thought too. But it's apparently not that simple, because this is pretty much exactly what happened to a man named Dwayne Barrett.
Right. The government looked at one single action and said, well, that violates two different paragraphs of the same law, so we want two separate punishments.
It feels like buying a burger and getting charged for the burger, and then getting a separate charge for the meat and bun combination.
That is actually a surprisingly good analogy.
So the case we're diving into today, it's got a robbery, a tragic death, and a whole stack of federal laws that seem to be tripping over each other.
They are. So our mission here is to really unpack how the Supreme Court decided this. Specifically, whether a lesser offense can exist alongside a greater offense when Congress hasn't explicitly said, yeah, we want you to punish this person twice.
It's all about what silence means in the law. Does it protect the defendant, or does it, empower the prosecutor? So let's start with the man at the center of this, Dwayne Barrett. This all started a long time ago, didn't it?
It did. We have to go all the way back to a crime spree between August 2011 and January 2012.
Okay.
Barrett was involved in a series of robberies. But the key moment, the one we need to focus on, was one specific terrible night. During one of the robberies, a man named Gamar Defala was shot and killed.
But Barrett wasn't the one who pulled the trigger, right?
No, he wasn't. The court records refer to his confederate as the shooter.
Whoa, hold on. Confederate. Are we talking about the Civil War?
No, it's just old-fashioned legalese for an accomplice, a partner in crime.
Oh, okay.
That just means he was part of the crew. And even though he didn't pull the trigger himself, under the law, he's responsible for what happens during the felony he's committing.
So he's on the hook for the robbery and all its consequences, and this is where the government starts stacking the charges against him.
Right, and this is, standard procedure for federal prosecutors. They want leverage. So they hit him with count 5, Hobbs Act robbery.
Okay, stop again. Hobbs Act. What is that?
It sounds kind of friendly, doesn't it?
It does.
It is not. The Hobbs Act is a federal law against robbery or extortion that affects interstate commerce. It's the hook that lets the feds get involved in what looks like a local crime.
So if you rob a convenience store that sells, I don't know, a can of Coke from another state.
Boom. That's the Hobbs Act. And that's the predicate crime, the anchor for everything else they charged him with.
Got it. So count 5 is the robbery. That's the foundation. What's next?
Then comes count 6. This is under 18 U.S.C., section 924C. And that statute makes it a completely separate crime to use a firearm during a violent crime.
Okay, so you robbed the place. That's count 5. And you brought a gun. That's count 6. Makes sense so far.
But then they added count 7. This was under subsection J of that same law. And subsection J makes it a crime to cause a death with a firearm during that violation.
Wait a second. So count 6 is using the gun.
Yes.
And count 7 is using the gun and killing someone with it.
Correct.
But you can't kill someone with a gun unless you use the gun.
You have hit the nail on the head. Think of it like a set of Russian nesting dolls. The big doll is count 7, causing death with a gun.
Okay.
Inside that big doll is the medium doll, count 6, using the gun. You physically cannot have the big doll without the medium one already inside it.
So why charge both? I mean, if you convict him of the murder with a gun, haven't you automatically proven he used the gun? Why do you need 2 separate convictions for the same act?
That is the multi-million-dollar question, or in Barrett's case, the 40-year question. He was originally sentenced to 90 years in prison.
90 years? Wow, that's a life sentence.
It is. After a lot of legal back and forth, it was knocked down to 50 years. But the specific fight that went to the Supreme Court was about those 2 counts. The trial judge, the district court, looked at the nesting dolls and said, this is silly. Count 6 is inside count 7. I'm merging them. One conviction.
Which sounds like just common sense.
You'd think. But the Second Circuit Court of Appeals disagreed. They said, no. Congress wrote 2 different paragraphs. Punish him for both.
And this is where the story gets really weird. Because usually, when a case goes to the Supreme Court, it's the defendant versus the government. Barrett says 1 crime, the government says 2 crimes.
Usually, yes. But in this case, the Department of Justice actually agreed with Barrett.
What? The prosecutors agreed with the guy they're trying to keep in jail?
They did. The Solicitor General's office basically said, you know what? We've looked at this again, and we think the trial court got it right. These should merge.
That's wild. Why would they do that? Just a sudden change of heart.
It's not generosity. It's about legal strategy. The DOJ's interpretation of statutes can change, and they might want to avoid a bad precedent that could hurt them down the line. But this created a huge problem for the Supreme Court.
Because if both sides agree, there's no dispute to resolve.
Exactly. If Barrett says, I win, and the government says he wins, who argues for the other side? Who defends the Second Circuit's ruling?
So what did they do?
The court appointed an amicus curiae, a friend of the court. They basically brought in a high-powered lawyer from private practice to argue the other side. To argue, no, actually, Barrett should be punished for both crimes.
That is so bizarre. It's like, the government doesn't want to punish you twice, but this lawyer we hired does, so let's hear him out.
It really shows how much the court wanted to get the law right. And to do that, they had to use a very specific legal tool, the Blockberger test.
Blockberger. Okay, I know this one. Sounds like a fast food joint, but it's actually a really old test from 1932.
It is the gold standard for double jeopardy.
Yeah.
The test asks, does statute A require proof of a fact that statute B does not? And vice versa.
Let's apply that to the Russian nesting dolls.
Okay, so statute A, the gun charge, requires using a gun in a violent crime.
Right.
Statute B, the death charge, requires using a gun in a violent crime plus causing a death.
So statute B needs something extra, the death. But statute A doesn't require anything that isn't already inside statute B.
Exactly. Everything in A is already in B. Therefore, under Blockberger, they are the same offense. And here's the crazy part. Everyone agreed on this. The government, the defense, the court, all of them said, yes, these are the same offense.
Okay, so if they're the same offense, and the Constitution bans double jeopardy, why are we even here? Why didn't they just bang the gavel and go home?
Because Blockberger isn't an absolute rule. It's more of a tool for guessing what Congress intended.
Yeah.
It creates a presumption.
A presumption.
It presumes Congress doesn't want to punish the same thing twice. But if Congress explicitly says, hey, we don't care about logic, we want you to punish this guy twice, then the courts will usually go along with it.
So the burden shifts. The default is 1 crime, unless Congress left a clear note saying, charge him double.
Precisely. And this is where Justice Jackson's majority opinion comes in. She basically went on textual treasure hunt. She scoured the law looking for that note.
And what does she find?
She focused on the phrase, in addition to. It turns out Congress knows exactly how to ask for double punishment. In the basic gun charge, subsection C, Congress explicitly wrote that the punishment has to be in addition to the punishment for the robbery.
So they spelled it out for the robbery part, punish for the robbery, and in addition to that, punish for the gun.
Yes, they did the same thing for armor-piercing ammunition. If you use those, you get extra punishment in addition to everything else. Congress was very specific.
But when it comes to linking the gun charge and the murder charge?
Nothing. Radio silence. There is no in addition to language there. Justice Jackson's point was, look, Congress isn't shy. If they wanted 2 convictions here, they would have said so.
So the entire case for double punishment, it collapsed because Congress forgot to take 3 words.
In the world of textualism, yes, words matter and silence matters. But the amicus, the court-appointed lawyer, he didn't give up. He tried to find a loophole in the sentencing rules.
This is the consecutive sentences argument, right?
Well, that's the one. Subsection C says its prison term must run consecutively to, meaning one after the other, any other term of imprisonment.
Okay.
So the amicus argued, look, the law says the sentence for the gun has to be consecutive to any other term. That must include the term for the murder. And you can't have a consecutive sentence without a second conviction.
You know, that actually sounds kind of logical. If the law says add this sentence onto any other sentence, shouldn't you add it?
It sounds logical, but the Supreme Court said it's completely backward. They called it putting the cart before the horse.
Ah.
You first have to figure out if a second conviction is even legal. Only then can you start worrying about how to arrange the sentences.
Right. You can't schedule a lunch break for a job you haven't been hired for yet.
That is the perfect analogy. If Blockberger says no second conviction, the sentencing rules just don't get triggered.
But let's play devil's advocate. Why was the amicus fighting so hard for this? Why did he and the Second Circuit think it was so important to stack these charges?
It all comes down to a fear of leniency. This is what we can call the menu versus buffet problem.
Okay, explain that.
So, subsection C, the basic gun charge, is very rigid. It has mandatory minimum sentences, 5 years, 7 years, 10 years. A judge cannot go lower.
Right. Prosecutors love that. It's a sure thing.
Exactly. But subsection J, the murder charge, is weirdly flexible. It has a high ceiling, up to the death penalty or life in prison, but has no mandatory minimum.
Wait, seriously. So you could cause a death with a firearm, get charged with subsection J, and a lenient judge could give you, what, probation?
Theoretically, yes, or a very short sentence. The fear was that if prosecutors couldn't stack the charges, they'd be forced to pick the bigger crime, the murder, but then lose the guarantee of that mandatory prison time.
So they wanted the buffet. They wanted to pile everything on their plate just to make sure the guy never gets out.
That's it. They wanted the security of the mandatory minimum plus the high ceiling of the murder charge. But Justice Jackson shut that down completely. She wrote, and this is the key line, that Congress intended to give prosecutors a menu, not a buffet.
A menu, not a buffet. That's the quote of the case.
It means prosecutors have to make a choice. If they're worried about a lenient judge, they charge subsection C and get those guaranteed years. If they have a truly heinous crime and want to go for life or the death penalty, they charge subsection J. But they don't get to have both just to cover their bases.
But I have to ask, does this make things easier for violent criminals? I mean, we're talking about someone involved in a robbery and a death.
Well, easy is relative. Dwayne Barrett is still serving 50 years. This isn't a get-out-of-jail-free card.
Right.
But it does restrict the government's power to stack charges. And that's a huge deal, because stacking is often used to force plea deals. If a prosecutor can say, plead guilty and take 10 years, or go to trial where I'll stack charges until you're facing 100, what do you think most people do?
They take the plea.
Of course. This ruling takes one of the most powerful cards out of the prosecutor's hand. It levels the playing field, just a little.
And it reinforces the idea that the punishment should fit the act, not how creative a prosecutor can be with the law books.
Precisely.
Okay, we have to talk about the plot twist at the end. Justice Gorsuch. He wrote a concurring opinion. He agreed with the result, but for a totally different reason that makes all this textual analysis feel, I don't know, kind of small.
Gorsuch went straight for the constitutional jugular. While the majority was using a magnifying glass to look for the phrase, in addition to, Gorsuch was looking at the Constitution itself and asking, why are we even doing this?
He went straight to the double jeopardy clause.
He did. Remember how we said Blockberger is just a presumption about what Congress wants?
Yeah, the idea that Congress can punish you twice if they really, really want to.
Gorsuch is questioning that entire premise. He makes a distinction between charging both crimes at once, like in Barrett's case, and trying them in two separate successive trials.
And everyone agrees you can't do successive trials. That's the classic definition of double jeopardy.
Right. If they tried Barrett for the gun crime and lost, and then came back a year later to try him for the murder from the same event, Blockberger would forbid it instantly.
Okay.
So Gorsuch asks this simple but devastating question. Why is it any different just because they charge them on the same day?
That is a really good point. Why is it different?
The historical answer has been that in a single trial, it's just a question of cumulative punishment, and that's up to the legislature.
Yeah.
Gorsuch thinks that might be completely wrong.
So he's essentially saying, I don't care what Congress intended.
Pretty much. He's arguing the double jeopardy clause says you shall not be twice put in jeopardy. It doesn't have an asterisk that says, unless the legislature really, really wants you to be.
This is huge. If he's right, then even if Congress had written in addition to, in neon lights, it might still be unconstitutional.
Exactly. It would take away Congress's power to create multiple punishments for the same offense. It would shift the ultimate authority from the legislature back to the Constitution itself.
That's a massive philosophical divide. You've got Justice Jackson saying, let's read the text carefully to find the rules, and Gorsuch saying, the ultimate rules are in the Constitution, maybe we should stop trying to guess what the statutes mean.
And for now, Jackson's view is the law of the land. They didn't need to go as far as Gorsuch did to decide this particular case, but he is planting a flag for the future.
He is. So let's bring it all back home. The Supreme Court reversed the Second Circuit. Dwayne Barrett gets one conviction for this act, not two. What is the big takeaway for you, for the person listening to this?
I think the takeaway is that definitions matter. The government cannot treat the criminal code like an all-you-can-eat buffet, scooping up every possible charge to bury a defendant. Unless the law is crystal clear, the tie goes to the citizen, not to the state.
It's a check on government overreach, even for people who have done terrible things.
Especially for them. Because if the government can bend the rules for the least sympathetic people, they can bend them for anyone.
I want to leave everyone with that thought from Justice Gorsuch. We spend so much time in these deep dives trying to figure out what lawmakers intended. We parse commas and definitions, but Gorsuch is asking us to step back and look at the bigger picture. If the Constitution says no double jeopardy, why have we spent the last century acting like it's just a strong suggestion?
It's a question that is going to be haunting the courts for a very long time.
Thanks for diving in with us. We'll see you next time.